the May VISA Bulletin is available and has brought some progress to the family-based petitions, but it has hardly changed anything in respect to the employment-based petitions. Let's evaluate the progress together here in today's video. And for those who do not know me, my name is Anna Schaefer and I'm an immigration attorney here in the United States. Well, let's start by comparing the dates for the visas for the employment-based category. The only change we've seen is in regards to the EB-4 for religious workers that wasn't available last for April visa bulletin, but now reappeared with the date of November 1st, 2020. All other dates remain identical to the month of April. Please note that in this video, we are evaluating the column that applies to all countries. We are not going to go in details of China, India, Mexico, and Philippines that has their own dates. And to explain further, the final action date corresponds to the date that the immigration visas are actually being issued. Imagine a ticket office. It's literally the moment of the delivery of that ticket. In order for you to know which date applies to your specific process, you have to know your priority date, which is the filing date of your visa eligibility. For those petitions that do not require a sponsor, such as the EB-2 national interest waiver, that you're going to consider the date of filing of the I-140, or in case of the EB-5, that will be the date of the filing of the I-526. For the family-based petitions, that will be the date of filing of the I-130, I apologize. Or for the case where a sponsor is required, such as the perm cases, then the date of your priority date will be the date of filing of your perm. Alright, so now I explained the final action date, I explained how to find your priority date. Let's talk about the date of filing. This is the date to start your consular processing. In regards to employment-based petition, when we compare April and May, there were no changes in regards to the date of filing. For those that are intending to do an adjustment of status, which is to request your green card issuance within the United States, the date to be considered by the USCIS for the employment-based categories remains the final action date. Not sure if you know that, but the dates to be considered for adjustment of status, different than the consular processing, they are not prefixed and they are determined on a monthly basis by the relevant US authorities. Until February this year, the date used to consider for the adjustment of status was the date of filing. However, since March, this has been changed to the final action date, followed by April and May continue considering the final action date for the adjustment of status. And when talking about this adjustment of status and about immigration as a whole, a common question I get is that if after the eligibility approval, let's say EB-2 national interest waiver, the form I-140, or family-based petitions, the form I-130, if my client can wait for the process in the United States? And the short answer is no. It's important to note that those forms alone, they do not grant you a valid status in the US or authorization to stay. You must either have another valid status and or have your priority date covered by the visa bulletin so you can apply for the adjustment of status. In other words, pending adjustment of status grants you authorization to be in the United States, but only the eligibility forms do not. In other words, pending adjustment of status grants you authorization to be in the United States, but eligibility forms alone do not. And attention, be aware to the maneuvers of coming to the United States in a tourist visa or a student visa and intending to do adjustment of status, because it might be understood that you entered the country and did a misrepresentation because you did not have an intent that was compatible with your visa, and that can be harmful for you. So make sure you talk to your immigration attorney if that's your intention. Going back to the visa bulletin, let's now take a deep dive on the green cards based on family relationships. In the Visa Bulletin, we have 5 subcategories. We have F1 for unmarried children of US citizens that are older than 21 years old. We also have the F2A for spouse and children that are unmarried under 21 years old of lawful permanent residents. We have also the F2B for unmarried children that are older than 21 years old of lawful permanent residents. Third preference for married sons and daughters of US citizens, and the fourth preference is for brothers and sisters of US citizens. You know that these categories have been frozen for quite some time, but we saw some great progress if compared to April Visa Bulletin and May. Had been some good progress here. So the F1 corresponding to the children of US citizens who are over 21 years old skipped 5 months from February 8th, 2015 to July 8th, 2015. The F2A corresponding to spouse and children that are unmarried and under 21 years old of green card holders skipped almost 1 year from September 8th, 2020 to June 1st, 2021. The F2B corresponding to unmarried children that are 21 years old or older of lawful permanent residents also went almost a year ahead from November 22nd, 2015 to April 1st, 2016. The F3 for married sons and daughters of US citizens went from October 1st, 2009 to January 1st, 2010. And even the F4 categories, which usually don't move much, also went from June 8th, 2007 to July 22nd, 2007. As of the filing date, that has not progressed much. The only category that changed was for the F3 category for married sons and daughters of US citizens, which went from March 1st, 2010 to June 1st, 2010. I know the Visa Bulletin can be confusing, so if you do have any questions, please leave here in the comments. I hope this video clarified to you the changes that happened, and I see you in the next video. And a quick reminder, this here, it's not a legal advice, but rather just informative material. Thank you very much for watching, and see you soon.